So these people that are doing these bonds, doing this stuff, filing their UCCs, allegedly doing administrative claims, which they don't have a right to do under the rights and duties of individuals because it's a claim against the state to which they belong, and they have no variation agreement under this UCC. Do you see how all this ties together, Ray? It all ties together. They don't have standing to do this, and they don't have a variation of agreement to do it. And you could do it before or after, but you can't do it unless you got stand. You can't do it in their rules, under their code, under whatever, U.S. Code, Title 28 or whatever. It says that tort is the exclusive remedy. The word exclusive means exclusive. There's only one remedy, and it's tort. What they're doing, what these other people are doing, Dorian, Freedom USA or whatever, it's not tort. They're not trying to get to where they come out of For My People, have rights, have standing, negotiate for and barter for a settlement on the tort issue. They're just trying to use the system against the system without a right to do so, because you have private international law, public international law. So if you're not a party to private international law, you don't have a right under, when they did this convention, which was in 1976, this is when they changed the organization to the International Conference of American States, became the Organization of American States. Then they, in 47, their first convention was not held actually until 76. They did CIDIP-1, which was their convention. They adopted 6 treaties or 6 conventions, the first one being the Inter-American Convention on Conflicts of Law Concerning Bills of Exchange, Promissory Notes, and Invoices. This is how they handle promissory notes, bills of exchange, and invoices among each other. Why? Because every government owns their banks. Every state owns their banks. These are U.S. banks. They're insured by FDIC. They're Federal Reserve banks. However you want to look at it, they belong to the Treasury. And they're dealing in deposits of public money. That's under, you go look at Title 12, Section 90. They are deposits of public money. So when you become a signatory to a bank account, you don't own the bank account. The bank owns the bank account because it's public money. You become a trustee of public money. But the bottom line is that if you're not a party to this convention here, where they've already agreed how they will handle a conflict over bills of exchange and promissory notes, then you can't do them unless the state that has an agreement on this contract allows you to do them. And people say, I've had people all the time say, well, we're just agreeing, we're going to stay in honor, we're going to offset and adjust the debt. Well, they haven't agreed that you can offset and adjust anything. People say, well, I don't have a conflict with it. I go, yeah, but they do. Why? Because they're signatory and you're not. You trespassed. Now they have a conflict. Whether you got one or not is irrelevant. Why? Because you didn't have the agreement. You created the conflict. Does that make sense?
Yes.
Okay. Wow, this is going long, but maybe we can wrap this up here. U.S. Code, Title 12. I mentioned Section 90. People don't read their bank contracts. They don't read the signature cards.
When you sign your name to sign without recourse, is that
You don't have a right to sign without recourse.
understood that was so that in case you were signing something that would make fraud, so that you would not be liable for fraud?
No, I know there's people who do this kind of stuff and they'll go void where prohibited by law, and that was under Article 5, 103C. We were just talking about whether or not you could vary these agreements. A term in an agreement or undertaking generally excusing liability or generally limiting remedies for failure to perform obligations is not sufficient to vary the obligation. So they took care of that one too. You actually have to have the variation by agreement, because it says in here that just making a statement like that in an agreement or undertaking, generally excusing your liability, like without recourse, without prejudice, void where prohibited by law, all that kind of stuff, it's not enough to vary the obligation. That's what it says right here. Okay.
So that they closed that loophole.
Yep. Might be one for them. It might be one for one who has standing, but it's not one for one who doesn't have standing. Yeah, exactly. Let's see. All national banks under Title 12, Section 90, all national bank associations designated for that purpose by the Secretary of Treasury. By the way, this doesn't say United States Secretary of Treasury. Shall be depositories of public money, and under such regulations may be prescribed by the Secretary. They may also be employed as financial agents of the government. What does that say? That means national banking associations are financial agents of the government, and they shall perform all reasonable duties as depositories of public money and financial agents of the government, as may be required of them. Secretary of Treasury shall require the association thus designated to give satisfactory security in the form of deposits of United States bonds, otherwise in safekeeping, for prompt payment of public money deposited within them, and for faithful performance of their duties as financial agents of the government. What's the point here? When you sign a signature card, you now have an agency relationship with a financial agent of the government. Therefore, you're a financial agent of the government. You're a trustee dealing in deposits of public money. And they're the ones that sign the account number. Why? Because it's not your account. You're a trustee over the account. They're the grantor. And if the grantor decides to replevin that property, they will do so. And that's why if you read the signature cards and all that kind of stuff, it says, and they did it to me. They proved it to me back in '99 when they told me we can take your money anytime we want to, because they did. We lost over 1.2 million, Ray. They did it. Not because they were ignorant, because I was ignorant. That's what she told me when she said, if you will read your contract with this bank, I can take your money anytime I want to. Now, by the way, this is also this bank contract where, if you read the deposit slip, it says checks and other items are received for deposit in accordance with the provisions of the Uniform Commercial Code and any applicable bank collection agreements. The IRS agreements are right there in that signature card. They don't have to ratify Title 16 because you ratified it in your personal contract when you became a public trustee. And under the Constitution, as far as that one is concerned, you're holding now an office of honor, trust, or profit under their Constitution, because that's what it says in Article 1 and Article 2 about holding offices for honor, trust, or profit. See, it told you right in the Constitution it was all about profit. People will always say, well, if they look at the code, they'll go in the definitions section of Title 26, Section 7701, subsection 26, where it says trade or business, and they'll say, well, I'm not a trade or business. It says it says to be a trade or business, you have to perform the functions of a public office. Well, if you're a trustee dealing in public money, guess what? You are performing the functions of a public office. You just ratified Title 16 into your own life, into your own contracts. They don't have to ratify anything because they're not going to bear the obligation of that contract. Okay. Oh, this is just other things, Ray. Do you have that little document? You've seen that document about the attorney-client relationship? It says a client is one who applies to a lawyer or counselor for advice in direction or in a question of law and commits his his first duties to the court and to the public, not his client. Okay. Yeah, going down to the bottom of that, it says that clients also called wards of the court, and the word war is inside the word war. I mean, war is inside the word ward, right? In other words, ward, that would be W-A-R-R-E-D. You ward against us. Now, therefore, you're incompetent. You're in dishonor, because wards of the court are innocent persons or persons of unsound mind. Why? Because this is about peace. It's not about war. You have to understand, Ray, when we go back to what we talked about with the rights and duties of individuals, this is a catch-22. Without a doubt, it's a catch-22. So how do you solve the catch-22? There's only one way. Come out of her, my people. That's it. There is no other way. Let's see what else we want to talk about here. I'm going to pull up, I'll go back into Word. I had other Word documents up. Attorneys?
Yeah, that I know.
Federal Rule 9A and 12H3, yeah, we're finished with that. I have a document called See and Hear. I think I have that up right now. The notes on the state of Virginia. We'll go back into history just a little bit more. The Armand Kondo letter. The Kondo letter, I'll go through this real quick. I'll point out one thing that he said. See, this whole taxation protest stuff, it's been going on forever. There's nothing new here, and they keep regurgitating, just like Freedom USA has done, Dorian did. They regurgitated the same stuff that the Freemen did in Montana. If you actually read and study what they did, the Freemen were not doing what everyone thought they were doing. And there was a lot of stuff that was right. But the issue came down to one thing, standing. They didn't have standing to do it. The rest is history now. But people keep regurgitating that history without the standing necessary to do these things.